My name is Michael Young, and I'm a lawyer who handles life insurance beneficiary disputes. In this case, I'll discuss a life insurance beneficiary interpleader case I had in federal court out of San Antonio. A lady called me and said that her brother had recently passed away and that she was the beneficiary of his life insurance policy. However, her brother was married, and the widow had a lawyer who wrote a letter to the insurance company saying that she was entitled to the proceeds. So the life insurance company had filed the interpleader lawsuit in federal court in San Antonio and had served my client. Now, fortunately for her, she did not wait or delay. She immediately called me, hired me to represent her interest in the case, and she was able to give me a pretty good background on what happened. And so I contacted the attorney for the widow, and I had a discussion, and I asked, what's really the basis for the challenge? And he said it was community property. Well, I explained to the lawyer that it was not a community property policy because he had purchased that policy before the marriage. So under the inception of title rule that Texas courts follow, that policy was separate property, even if some community funds were later on paid for the premiums during the marriage. And there was no allegation that there was any fraud involved in the designation, no reason to contest his mental capacity or anything like that. So ultimately, I was able to convince the widow's lawyer to just drop the claim. And my client was awarded the entirety of the policy proceeds by the federal judge. Does it always work out that well? No. Does it always work out that quickly? No. But the moral of the story is, if you're facing an interpleader dispute, contact a qualified attorney as soon as possible so we can discuss the facts of the case, potential defenses, and sometimes head off a dispute before it can get too far down the road.